The driver attached to Judiciary Stanley Kisambira has been arraigned in the Standards and Utilities Court in Kampala to be charged with offences that led to his arrest. Before Chief Magistrate Gladys Kamasanyo, driver Stanley Kisambira was first charged with the offence of hate speech, although he denied it.
The charge against you is that of hate speech, which is contrary to section 26A, capital A, 1, subsection 1, paragraph C of the Computer Misuse Act of 2011, as was amended last year of 2022. The law is the Computer Misuse Act of 2011, which was amended in the year 2022. Okay, these are the particulars, Stanley. Yeah, the particulars are that you, Kisambira Stanley, on the 12th day of the month of May, the year 2023, within Uganda, through a computer, you shared on the Uganda Judiciary Transport WhatsApp group.
WhatsApp group ya Uganda Judiciary Drivers Group.
Transport WhatsApp group.
WhatsApp group ya transport WhatsApp group.
You shared information on that group of WhatsApp.
Group ya WhatsApp onobaka wachekayo.
To wit, this is the information. A recorded audio which was likely to promote hostility, and that this was likely to promote hostility against judges in the judiciary of Uganda over and above those of their drivers. The judges' salaries. That judges' salaries are unfairly over and above those of their drivers. And that a driver can decide to cause road accidents by ramming into a moving truck, thereby killing the judges and their bodyguards. Did you understand what was explained to you? But you said you didn't understand. We'll read them again.
Prosecution told court that investigations into the matter are still ongoing. Stanley Kisambira, through his legal team, prayed to court to be granted bail by presenting three sureties, among others, Babali Francis, Wambiro Nadi Patrick, and his wife Grace Muksa.
In the charge sheet, unfair treatment, words relating to unfair treatment. The offense does not involve any violence, but rather involves, from the particulars in the charge sheet, words relating to the unfair remuneration of judges' drivers. Your Honor, the accused person has no criminal record. Your Honor, he's, again from the charge sheet itself, a driver of the judiciary. They have fixed places of abode. They've provided documents relating to their workplaces. That is to say, employment IDs for sureties number 1 and 2, and an introduction letter, Your Honor, to the third surety regarding her stationary business in Gunga. So, Your Honor, we pray that you find them, that they are substantial, and we pray for a non-cash bond for the accused person on the basis of the 235,000 shillings that he receives as salary.
Please make a submission. So if we have this camera and you want to play
But Your Honor, the basis for a non-cash, and that is why we, Your Honor, Section 56, the court is the employer of the accused person. So Section 56 requires us to take judicial notice of these records.
You are the one who wants to do that.
So Your Honor,
for you and when you
Your Honor, and Your Honor, we're giving.
200. What should be done with 100?
Your Honor, the prosecution will rebut in their submission. Your Honor, I pray that I give you grounds why you should grant a non-cash bond. And Your Honor, allow me to proceed. Where you find that my submissions are lacking, Your Honor, you'll give a ruling.
However, prosecution rejected the application, saying that all the sureties don't meet the required standards for bail, being that they have failed to clearly identify their places of residence, among other factors.
Your Honor, he has presented an introductory letter from his ancestral home. Your Honor, that is not what the rules say. He had to present an introductory letter from the place where he resides. And he had told Your Honor, he had informed police that he stays in Sazagulu zone in Mukono district. So Your Honor, he has not furnished us with the introductory letter from the chairperson LC1 from Sazagulu, and neither has he presented his national ID. Your Honor, therefore releasing the accused person would be very risky. Your Honor, there are two tenants in grant of bail which I wish to submit a point. That when bail is granted, will the accused person show up? If he doesn't, is it easy for the authorities to trace for him? Your Honor, if Mr. Kisambira doesn't show up, the police authorities have nowhere to start from. They don't know whether he could shift, whether he has a fixed place of abode, whether he rents in Sazagulu. It's a complete mystery. That ground alone would pray that bail is denied. He has not complied with the mandatory guideline from the Chief Justice that upon applying for bail, you furnish the court with an introductory letter and a national ID of their deputies, subordinate officers and assistants, and also all officers acting in execution of its process, and of all advocates and all other persons authorized by law to appear or act on their behalf. Your Honor, drivers are not envisaged in this section, so they cannot be judicially recognized. So, Your Honor, therefore, surety number 1 had to prove, just like the rest of us, that he has a fixed place of abode. Your Honor, he presented a letter. It's of very little relevance. It doesn't tell us anything about the surety. whether he has a fixed place of abode, does he have his own house, does he rent, the names of the landlord, if any.
He asked court not to release Stanley Kisambira on bail and to impose strict bail terms unto him. Magistrate Gladys Kamasanyu, however, dismissed the prosecution's prayers, thus releasing driver Stanley Kisambira on a non-cash bail of 10 million.
His wife and a nephew. I have listened to submissions of counsel for the applicant and the ones for the state attorney. This court is clothed with the discretion to grant or deny bail to the applicant, and where bail is granted or denied, for sure, reasons for any of those decisions must be given by court. And in granting bail, court must balance the rights of the accused and those of the complainants. And in this case, I bear in mind that the accused person is actually still presumed to be innocent, since he denies the charges, he denies the allegations, and the prosecution has not yet adduced evidence to show beyond reasonable doubt that he did commit the offense. In granting bail, court is under duty to ensure that the applicant actually returns to court and answers the charges to the end, which is mainly the complainant's interest, to see that the case they report to court is heard to the end. In this case, the accused has presented before this court his employer's ID together with his national ID. The national ID of the applicant details the applicant's place of abode, which is the same as the place that is on the charge sheet before our court. There is no more requirements to prove place of residence beyond that. You have the national ID and you have the place of residence indicated by the very people who are charging the accused. I need to also make it clear that the bail guidelines of the Honorable Chief Justice of the Republic of Uganda are guidelines to courts while considering bail applications, and they are very clear. There is no requirement as accused should be proving places of residence, employment, and as making them mandatory. As long as court is satisfied that the applicant can be traced and be brought back to court, can continue to answer the charges to the end, that should suffice. And in this case, the applicant's place of residence and his place of work actually are not in dispute. As regards his sureties that he presented before court, these are all sureties that have proven to court to know the applicant. They are all adults who are reasonable members of this nation, who are possessed with the potential to trace for the accused and also actually compel him to return to court as and when he is needed by this court. They are his people. Those are his people who know him better. Court cannot insist on him presenting any other sureties. The sureties presented are actually substantial. The bail guidelines do not make it mandatory for sureties to present letters of LC detailing all that the state attorney has talked about, much as that decision of the judge that, like counsel has said, that was delivered before the guidelines says so. The bail guidelines do not make it mandatory for the sureties to present letters of introduction detailing all that the then state attorney talked about in his submissions, but the guidelines do invite courts to take into account the factors listed by the guidelines, which this court has actually done and found that the sureties do satisfy the requirement of standing as a surety. For instance, the guidelines state that the surety should present mandatory documentary proof including an introductory letter from the LC1 chairperson of the area where they reside. Each of the sureties before our court has presented a letter of introduction, on top of them presenting their national IDs. All in all, these are substantial sureties in the circumstances. The accused person, having presented substantial sureties before a court, charged with an offense that is bailable by this court, still presumed to be innocent until the state adduces evidence to prove him guilty, he's given a chance to answer the charge from home as opposed to coming from prison. He's therefore today granted bail. These are the terms. It is bonded the sum of 10 million Uganda shillings. This is not in cash. Each of the sureties will execute a non-cash bond of 5 million Uganda shillings only.
The court resumed on 12th June 2023.
So today, finally, the court has done what it should have done on Monday. I know some people are excited. Personally, I'm not excited because it should not have happened. Mr. Kisambira should not have gone to Luzira. Mr. Kisambira should not have been arraigned before court. Mr. Kisambira should not have been prosecuted. So the excitement, I think, really it's unfortunate that we have to be excited over court doing what it should have done on Monday. So today court has reconfirmed that Mr. Kisambira is still innocent, very, very innocent, and it has accordingly granted him bail, a non-cash bail bond of 10 million shillings, and the sureties have been bonded at 5 million shillings each.
What happened on Monday?
On Monday, we appeared with for Mr. Kisambira in courtroom 3. Unfortunately, he was taken to a different courtroom. We were never informed. We only attended towards the end of the proceedings. So we protested the irregular manner in which he was arraigned before court without informing his lawyers who were within the court premises in a different courtroom where he was meant to appear. So he was remanded without taking plea. He was remanded without being given an opportunity to exercise his right to apply for bail. We are glad that today he has exercised his right and the court has found merit in his application and accordingly granted it. I do not think that we should or we shall have a hearing. I think what we have is not a criminal matter. What we have should be a labor complaint. What we have should be a constitutional matter. I think what we should have is a political discussion on how we treat drivers, on how we treat support staff. You can tell this from the what has been going on in the courtroom. You've all heard about how drivers are not considered, are not taken to be officers of court. So this is a discussion we should be having as opposed to having a criminal trial. On our part as the defense team for Mr. Kisambira, we are very ready to enter into the legal arguments, but we very well would want this to be a political discussion, a discussion on how we treat the drivers, how we treat the court clerks, how we treat other people subordinate in the judiciary system.
Stanley Kisambira is accused of posting an audio that went viral on different social media platforms, showing dissatisfaction with a monthly salary of 200,000 as a judiciary driver. Stanley Kisambira has been in custody since Tuesday this week after being remanded by Uganda Road Court